कॉम्बिनेशन में करते हैं। और एक ये जो आर्बिट्रेशन एक ऐसा सेशन है जो जनरली व्हेन वी वर टॉकिंग टू जस्टिस मिड्डा वी फाउंड दैट lot of sessions normally are in English only, but arbitration as such is growing a lot. So सोचा कि इस सेशन को भी उस तरीके से समझा जा सके जिससे कि एक आम आदमी समझ सके, सोच के सोच सके कि इसमें अपना करियर बनाना चाहिए कि नहीं बनाना चाहिए। इमर्जिंग ट्रेंड्स इन आर्बिट्रेशन में जब जस्टिस जे.आर. मिड्डा बताएंगे तो उनमें जब बातचीत हुई, not only what is the scope in arbitration, how the legal journey has traveled all these times. These are different aspects where we'll be taking the session across, so that one can also understand what are the skill sets required along with the various aspects. The discussions regarding the trends, emerging trends would mean that how the judgments are there, and those who have been connected, not as such with Justice Midha, we can say that those who follow up the judgments would know that there are a lot of judgments which actually were trend setters. So I can say in a lot of judgments, Justice Midha actually set the ball rolling and set the trend setting. In fact, so much so, we had, sir, I will share with you, we had one of the cases today, we had booked it in respect of disposal of properties. And I saw one judgment of Justice M.S. Shah and coupled with one of your judgments as to how the disposable properties of perishable goods, etc. should be done. So I thought that in all fields, whenever you touch the law, you find a lot of judgments of Justice Midha on these aspects. समय ना लेते ज्यादा, मैं जस्टिस मिड्डा को ही रिक्वेस्ट करूंगा कि सर इमर्जिंग ट्रेंड्स के ऊपर बताएं और क्या करियर में भी क्या स्कोप्स हैं और कैसे कैसे उन्होंने भी अपने सॉफ्ट स्किल्स करने और क्या लॉ में भी चेंजेस आए हैं विद द फ्लक्स ऑफ टाइम फ्रॉम 1940 till 1996 and the latest amendments in the act. Over to you, sir.
Thank you, Vikas. Thank you very much. So I welcome all the participants who are here. And it is a good platform which Vikas has created to share the knowledge and also enrich and be updated on the law. So this is a good outcome of the COVID that we have used this opportunity to share the knowledge and update on the knowledge on this platform. So today's topic is a very interesting as well as useful topic with respect to the arbitration practice. You see, all of us know that how we have traveled from Arbitration Act of 1940 up to 2019 amendment. And one main reason for this development of law by numerous amendments is that arbitration law is the most important law for the economy, because most of the cases which are covered by the arbitration are commercial contracts, and therefore it is most important that if any dispute is there between the parties relating to the commercial contracts, it should be resolved expeditiously and then also enforced expeditiously, so that the businessman is able to continue with his business and the economy grows. And the law simultaneously, if you see, the law simultaneously all over the world was developing, and therefore all the investors who are there, they probably also, investors and other countries, they also had a point of view that they will invest the money only if there is a good and strong legal system and also a good and strong arbitration system for the businessman to ensure that in the event of any dispute, then he is not unnecessarily choked in a long drawn litigation. I remember when I was elevated in 2008, at that time, there was not much of institutional arbitration. So immediately after my elevation, I had an opportunity to go for a conference on international arbitration to Singapore. And there I had the opportunity to visit the Singapore International Arbitration Center, which had at that time recently been set up. by the Supreme Court. The Supreme Court in Singapore had shifted their building from a heritage building to a newly constructed building, and the old Supreme Court building was constructed into an arbitration center. And there we had seen those rules of Singapore International Arbitration Center. And when we examined those rules and we came back and we discussed with our then Chief Justice A.P. Shah, who then constituted a committee to examine the issue and as to the opening of a similar arbitration center annexed to the High Court in Delhi. And in 2009, Delhi High Court started the first court-annexed arbitration center, that is Delhi International Arbitration Center. And we had framed the rules which were commensurate with the best international standards. So that was the time when the institutional arbitration started. And then gradually it increased, but still ad hoc arbitration was much in practice. And then the government brought the amendments in 2015 and 2019. All of you are well aware that the major changes which have been brought are that now there is a time limit which is fixed, 6 months for completion of pleadings, and then 1 year for the completion of the arbitration from the date of the completion of pleadings. And when an arbitrator is appointed, then he has to also give a declaration. And in terms of Section 12 of the Arbitration and Conciliation Act, and also the schedule which gives the requirements for the impartiality of an arbitrator. So this is a major change which is brought about by the law with respect to the time limit of the arbitration. And also the arbitrator has to declare that how many arbitrations he is doing presently and whether he would be in a position to complete the arbitration within the statutory time period prescribed in the amended act. But one major change and breakthrough which came in the arbitration law was by the judgment of the Supreme Court, when the Supreme Court said that an interested party cannot appoint an arbitrator even if the arbitration clause provides for the appointment by that person. So therefore, the entire major trend which changed, and which you can say major improvement which came to the appointment of an impartial arbitrator, came with the amendment of the Arbitration and Conciliation Act. And that was a major change. So now no litigating party can appoint an arbitrator, and the clause which provides for such appointment is no more enforceable in law. And therefore, in all such cases, the appointment, the parties have to approach the High Court under Section 11 for the appointment of an arbitrator. So this is a very, very positive and good change, which has changed the color of the arbitration. And now, in all cases, the impartial arbitrators are being appointed. So now, so far as the power of the parties to nominate an arbitrator is concerned, it is only left to those cases where the arbitration clause provides for appointment of 3 arbitrators, 1 to be appointed by each party, and the presiding arbitrator to be appointed by the 2 arbitrators nominated by the parties. So this is in the last few years, the changes which we have seen in the legislative changes as well as by the judicial pronouncements are a major change. And this is a very, very positive change. And to my mind, this trend of in the arbitration law which has started in the last few years, the way it is continuing, we are moving toward you can say a further better system to match with the best practices of the international arbitration. Now today I will discuss one very important aspect which has not much been discussed, that is the scope of the terms morality and justice in Section 34 of the Arbitration and Conciliation Act. You see, all of us are aware that the scope of objections in Section 34 is very, very narrow. And certainly, Section 34 objections cannot be compared or even treated as to with the right of appeal which normally a party has got against the judgment and decree of a civil court. Therefore, the scope is very, very narrow, and ordinary rule is that we should not interfere with the award, but for those conditions which are met out. But one major clause which is not been much interpreted or considered or looked into or invoked is explanation 1 to Section 34, explanation 1, clause 3 small I, which says, then award is in conflict with public policy of India if it is in conflict with most basic notions of morality or justice. So the terms, so if a award is against most basic notions of morality or justice, then it is against public policy and therefore it is liable to be set aside. Now, in the judgment of the Supreme Court in Associate Builders, Justice Nariman interpreted these two words, morality and justice, and the interpretation given was that if it tricks the conscience of the court, then it can be said to be against most basic notions of morality or justice. So question rises, in which case? So question rises, in which facts of the case it can be said, and such a interpretation can be given. Now, one very important aspect before we examine the example of morality or justice is that on one hand, the scope of Section 34 is very, very narrow. It is a very, very narrow, it is narrowest, because general rule is that we should not interfere with the arbitrator awards. Parties have themselves chosen to have an arbitrator, therefore they should comply with the award, and the award should not be interfered with. So therefore, so far as the entry into the realm of objections of an arbitrator, they are very narrow. But on the other hand, the terms morality and justice are so wide that if they prick the conscience, so one very nice example of this case. So this term conflict and justice, I had the occasion to deal with it in two cases. I'll just briefly discuss the facts of that case. In one of the cases, the bank, it is a case of Kotak Mahindra Bank. So Kotak Bank had taken a property on lease in Noida on rent on a long lease. So after a few years, the rent of that property fell down and the adjoining property was available at half of the rent. So the bank approached the landlord that, look, the rents have fallen and the adjoining property are available at half the rent. So you either reduce the rent or we will terminate the lease and we'll vacate and take the adjoining property on rent. So the landlord, after verifying the position, landlord agreed to reduce the rent. So from 10 lakh, it was reduced to about approximately 5.5 lakhs. And a supplementary lease deed was executed between the parties. And the bank started paying the reduced rent after about 2 years or so. 2 years or so, the landlord demanded again the original rent which was there in the lease deed, and to which the bank objected, saying that the rent had been reduced and a supplementary lease deed was executed. To which the landlord responded saying that he had not agreed for the decrease, and so far as the supplementary lease deed is concerned, that is unregistered and therefore not enforceable. So the landlord invoked the arbitration, which was, and the learned arbitrator held that the supplementary lease deed is unregistered, cannot be looked into. Therefore, the bank was held liable and the award was passed in favor of the landlord, directing the bank to pay the original rent of 10 lakh rupees. The objections against that award were filed before the Delhi High Court. So in Delhi High Court, the stand taken by the landlord was, first, that he had not agreed to the increase, to the decrease of rent, And secondly, the supplementary lease deed was unregistered. So now question here arose that even if the supplementary lease deed is unregistered, but this award is against the morality and justice. It pricked the conscience of the court, because the landlord is not an honest person. He himself had signed that lease deed, and there were communications where he had admitted that having signed that signature on the document, he had not denied. So the court took the view that, first of all, it appears to be against morality and justice. And secondly, the landlord has raised false claims in the objections before the High Court, for which the action under Section 209 of the Indian Penal Code would be warranted. At that stage, up to that stage, the case was before me, and thereafter the parties settled the matter, but therefore no judgment came in that judgment, in that matter. Now the second case, this was long before, this case is I think few years back, and is not reported. But thereafter, the term morality or justice again came up before the Delhi High Court in another case, in which another case of Ganesh Benzoplast versus Morgan Securities and Credits Private Limited. This is reported as 2021 5 AD Delhi 602, in which it was the issue of a loan, where the loan was given for a particular period, and the agreement contained the clause that if the loan is not paid within the specified time, then the compound interest of 36% with monthly rest would be levied. And by that calculation of 36% with monthly rest, the 38 lakh rupees which were due and outstanding against an institutional loan became 90 crores over a period of time. And it became more than 1,000, I think it was 1,036%. So the High Court took the view that this appears to be against most basic notions of morality and justice. Although the interest at the rate of 36% per annum, the borrower was willing to pay simple interest. And on that basis also 38 lakh rupees had become approximately 2.5 crore or 3 crore rupees. So the court took a prima facie view in interim application. The final objections have not yet been disposed of. I think they might be still pending. But in an interim application for which was before the High Court, there the High Court took that observation and interpreted morality or justice. But there are not much case law on this, and the term morality or justice is still to be interpreted and examined by the highest court. But it is a very important provision which has to be invoked. And kindly see one very important aspect. When we in a civil court, the appellate court under the Code of Civil Procedure is not empowered to look into morality. There, although the powers are very wide, powers of the appellate court are very wide, the appellate court sits in jurisdiction over the original judgment and decree and re-examine the entire thing, re-appreciate the entire evidence. But at the same time, the appellate court is not empowered to look into the morality. It is required to look into the legality. And there's no specific provision in the Code of Civil Procedure that the appellate court can set aside the judgment or decree of a civil court on the ground that it is against most basic notions of morality or justice. Therefore, on one hand, whereas the scope of Section 34 is very narrow, on the other hand, there is a very, very wide gate opened on the back, where the court is empowered to set aside an award if it is against the most basic notions of morality or justice. And the words most basic notions of morality or justice are not defined anywhere. Therefore, in Associate Builder, the Supreme Court interpreted that provision. And again, the interpretation they given is also quite wide, that which pricks the conscience of the court, which is a very wide connotation. And but kindly see, as the Kotak Mahindra Bank facts were very clear, to my mind, in such cases or similar cases where Now, if we go in Kotak Mahindra Bank, if we go by the term legality, then the award was perfectly legal, because the supplementary lease deed by which the rent was reduced cannot be looked into evidence. But if you see from the morality point of view, a landlord who had agreed to reduce the rent, who signed the supplementary lease deed, who acted on supplementary lease deed and accepted the rent for more than 2 years, suddenly after 2 years turns dishonest and wants to take the benefit of non-registration. So therefore, although his claim may be legal, but his claim cannot be certainly be said to be moral, and it is against the most basic notions of morality or justice. So to my mind, again, since we are discussing emerging trends, so this is a trend, and we'll have to see how this term is interpreted and acted upon and also applied in future, on which there is not much case law. So this was a to my mind very important topic, which we will see in the coming time how it is looked into and interpreted and applied in the cases. So this was one issue I thought I will share on this platform today. The second also very important issue which has recently come by judicial pronouncements is the enforcement of an emergency arbitrator. Now, this emergency arbitrator is also a new concept. So emergency arbitrator concept is not incorporated in the Arbitration and Conciliation Act, but emergency arbitrator finds place in the rules of the institutional arbitrators in Delhi International Arbitration Center. It provides for emergency arbitrator. Other domestic rules also, I think 3 or 4 institutions in India, they also provide for emergency arbitrator. And certainly the international institutions such as Singapore International Arbitration Center provides for an emergency arbitrator. Question arises, who is an emergency arbitrator and how is that emergency arbitrator be appointed? Now, for example, in Singapore International Arbitration Center, now in that case of Amazon, in which the Supreme Court has given the judgment on 6th August 2021 by Honorable Justice Nariman, there the agreement provided that in the event of dispute, both the sides will appoint one arbitrator each, and the 2 arbitrators will appoint a presiding arbitrator, and the arbitration shall be carried out according to the rules of Singapore International Arbitration Center. Now, this process, there were time limits on the appointment also by the parties and thereafter by the 2 nominated arbitrators. Now, then there is a separate provision that in the case of any emergent relief which a party may claim, then if any of the parties can approach the arbitration center, and the arbitration center, upon receipt of the application, shall appoint one independent arbitrator from its panel as an emergency arbitrator, and that emergency arbitrator shall call for the reply to the interim relief application, and after completion of pleadings, hear the arguments and pass the award within 15 days. Now, kindly see, the normal arbitral tribunal comprises of 3 arbitrators, one to be appointed by each party. But so far as emergency arbitrator is concerned, it has to be appointed by the institution. And that emergency arbitrator has to decide within 15 days. Now, the Act does not define the word emergency arbitrator, and the Act also does not contain any provision. Although prior to the amendment, the Justice Shri Krishna Committee, which was set up and which gave the recommendations, had recommended for this to be incorporated by the Act, but that was not incorporated. So in the case of Amazon before Delhi High Court, question arose whether emergency arbitrator is an arbitrator within the definition of arbitrator under the Act, and whether the award of emergency arbitrator is enforceable under the Arbitration and Conciliation Act. So this provision was examined, and the High Court, Delhi High Court, took the view that the award, that an emergency arbitrator is an arbitrator within the purview of the Arbitration and Conciliation Act, and the award of an emergency arbitrator is an order under Section 17(1) of the Arbitration and Conciliation Act, and is enforceable. So this judgment of the High Court was challenged before the Supreme Court, and the Supreme Court, by the judgment of 6th August 21 by Justice Nariman, upheld the view of the High Court that the emergency arbitrator is an arbitrator, and the award of emergency arbitrator is an order under Section 17(1) of the Arbitration and Conciliation Act. Although in that judgment, the Supreme Court only decided the question of law, and the decision on merits was not examined. And later on, by a recent judgment of, I think, a few days back, a few weeks back, in this month itself, the Supreme Court has remanded back the matter for adjudication on merits. But so far as the question of law relating to the validity and enforceability of the award of an emergency arbitrator is concerned, that stands by the judgment of the Supreme Court of 6th August, and it is a very important development, because so many international arbitrations are there where the emergency arbitrator award issue is there, and in domestic arbitrations also, the institutions, the Indian institutions also contain the provisions relating to the emergency arbitrator. Although in the domestic arbitration still, this provision has not yet been invoked, at least to my knowledge. So this was a very second aspect, new trend which has emerged in the recent time, and it is a very important, you can say, adjudication by the Supreme Court on this question of law with respect to the emergency arbitrator. So this is again one issue which is a recent development, but it is an important development, especially with respect to the international arbitrations which are there. Now, third very important aspect, which I would like to today discuss, is how to compute. You see, as we have discussed earlier, most of the arbitrations deal with the commercial disputes. There are disputes between the parties, commercial disputes where there is a breach and one of the parties claiming damages. So invariably, you will find that the breach of agreement and the party is claiming damages arising out of the breach. Now, and in every such case, the question rises, how to compute the damages? How to calculate the damages? So invariably, I'll just give a very example of a case which I had an opportunity to conduct in arbitration before my elevation, before a arbitral tribunal comprising of 3 arbitrators, out of which 2 were former judges of the Supreme Court and 1 former judge of Delhi High Court. So there was a agreement between the parties for a period of 20 years to operate a hotel, and for 20 years, and one of the parties terminated the agreement after 1 year. So the second party claimed the damages for the remaining, claiming the amount which he would have earned in the remaining 19 years. And the case was at the stage when the arbitrators were at the final stage, when the arbitrators were considering to award the amount which the agreed party would have earned in the remaining 19 years. It was at that stage when I was engaged and I looked into the matter. Now the question here is, the most important thing to be seen in damages is that whenever there is a breach of agreement, first of all, there is a duty of the other side, agreed party, to mitigate the losses, whatever can be reduced. So if the agreement would have continued for next 19 years more, and now the agreement has been terminated, so all the employees, all the consumables, all the other things which the other party would have to to engage to provide the services, they are no more required. Therefore, the parties is required to mitigate, and that mitigation will bring that amount, substantially bring down that amount to a lower amount. That part, once we come, let's assume amount was X, by mitigation it should come down to at least less than half. Now let's assume it comes from less than half. Then also that is not the amount which is the loss. That is the amount which would have been the gross accrual of the aggrieved party. And on that gross accrual, for getting that gross accrual amount, that party was required to invest the time, human resource, and other things, and expenses. And so therefore we have to go back and see the balance sheets of that person. And so as in that case, given case, when we looked into the balance sheets, we found that from the balance sheets of that aggrieved party, who was claiming compensation, their profit before tax was only 8% or so. So question rises, if the person would have earned 100 rupees, he would have only saved the 8 rupees, and the remaining money would have been just spent by him as on the execution of the contract. So therefore, loss is not of the gross amount which that party would have accrued or earned in 19 years, but the loss is what is the gross profit before tax, net profit before tax, which the party would have earned from that contract. So meaning thereby, if it is, let's assume the party would have earned 100 rupees if the contract would have continued, then by mitigation it will come down to, say, let's 40 rupees, and then not 40, it will come down to 8%, which will come down to further about approximately less than 4%. So in that particular case, a claim of 20 crores came down to 12.5 lakhs by applying all these principles. Although this preposition which I have discussed appears to be quite simple, but in many of the cases before the High Court, when the awards came before me, I found that this principle had neither been invoked, nor been applied, nor being raised in objection by the objector. But it is a very important principle. So therefore, this aspect, to my mind, is very important in all claims of damages, that a person should keep in mind as to how to compute the damages. One more very important similar case, although it is not an arbitration matter, but again the principles which are applied for computation of damages and for computation of damages in civil court or in arbitrator, they are the same. There are no separate you can say earmark for as to in which cases what principle will apply. So similarly, in one more very clear example was there, that where a person was engaged as he was an engineer. He was engaged as a expert engineer to provide his services in a building contract for a period of 1 year, but the builder terminated the contract after a month or so, being dissatisfied with the services. So the expert engineer filed a suit for recovery before the High Court, in which he claimed the total amount which was mentioned in the contract. So when the witness came for cross-examination, we asked the witness as to how much money he would have spent on the performance of the contract, and then how much is the net profit he's reflecting in his tax returns. And we found that then after applying the rules of mitigation, and after deducting the expenses, and after deducting taking the net profit from the returns, it came to a very negligible amount. Therefore, this is a very important aspect to my mind. Although a case came before me to lay down this principle, but I could not complete the hearing of that case. Therefore, there is no judicial pronouncement I could see on this aspect, although the principle of law which appears here is very simple. So these three aspects are very important. Now, one more aspect which again is a recent development, is a case where the award, the execution of an award was filed against a foreign country, and the question arose as to whether a foreign country can claim immunity, sovereign immunity. And second was whether prior consent of the central government is necessary under section 86(3) of the Code of Civil Procedure to enforce an award, arbitral award against a foreign state. On this case also, the High Court examined the cases on the subject, and then after examining all the cases, then the High Court, in a case of this is again 2021, KLA Construction Technologies Private Limited versus Embassy of Islamic Republic of Afghanistan, 2021 280 DLT 321, in which the Delhi High Court ruled that prior consent of the central government is not necessary under section 86(3) of the Code of Civil Procedure to enforce an arbitral award against a foreign state. And second, a foreign state cannot claim sovereign immunity against enforcement of an arbitral award arising out of the commercial transaction. Here also, the court again went in detail into all the previous case law on the subject and interpreted and reconciled and laid down the ratio that no sovereign immunity can be claimed by a foreign state in cases of enforcement of an arbitral award. So this is again a recent development and a very important development, because there are many commercial contracts which are executed by the foreign embassies here. In both these cases, there were two cases where two foreign states were involved. First was the Republic of Afghanistan, and the second was also a foreign state. And the very important question, and in fact, central government was also called for, and the central government took a clear stand that no prior consent of the central government is necessary under section 86(3) of the Code of Civil Procedure. So these are the recent developments which are of a very important aspect, and the way the arbitration practice and rules and the pronouncements and amendments are moving. To my mind, the law is developing in a right direction. Although with respect to the 2019 amendment, where it provides for the arbitration council, which provision has not yet been, that council has not yet been framed, and there are different views on with respect to the government control in it, and but that will have to be seen when the things come. But the majority view taken in by the judicial experts is that the government control in the formation of that council is not advisable, and the arbitration should be left to be an independent institution to grow. And to my mind, the best thing is that institutional arbitration is better than the ad hoc arbitration, where the things can move in a right direction. And more particularly, first of all, whenever the parties agree to do the arbitration according to the rules of an institution, the important benefit they get is the appointment of an impartial arbitrator by the tribunal. Otherwise, in the case of disagreement, in every case, the parties have to approach the High Court for appointment of the arbitrator. So therefore, the parties, by nominating an institution and agreeing to do the arbitration according to the rules, can avoid that one legal proceedings initiated just for appointment of an arbitrator, which also not only involves legal cost, but also the time frame. So I think this is and one last thing which again, although is not purely on arbitration practice, is that where the parties raise false claim, and when the matter comes in objection under 34, the court can certainly look into, court can certainly invoke 209 and take up the matter wherever the false claims are raised by the parties, because at times the parties raise false claims without impunity, without realizing the consequences of raising a false claim under section 209, on which there is a judgment of the Delhi High Court, where the principles relating to the false claims have been laid down by the High Court in the case of HS Bedi versus NHAI 2016 SCC Online, Delhi 432. So I think because this is a sufficient coverage we have done to the emerging trends of arbitration, and the
question is that you can only guide to a particular level, then the lawyer and the law develops with the flux of time. It just gives the bird eye view that what can be this thing. This is by Sarveshwar Kanan. Therefore, your lordship is of the opinion that it is not the contract value, but the EBIDA, that is the damage that can be claimed with the respective breach. It is his question by Sarveshwar. There's only one question.
Sorry, what is the question? Will you repeat again?
He says, sir, according to you, it is not the contract value, but the EBIDTA, that is the damage that can be the claim with respect to the breach.
You see, on that, the section 74 itself is clear. Contract value can never be claimed as a matter of right. You see, section 73 of the Contract Act says that a party can claim the general damages, which were within the knowledge of a person that the person would suffer if the contract is breached. And if there are some special circumstances which were brought to the notice, then even special damages can be claimed. And section 74 says that if liquidated damages are mentioned in the contract, that in the event of breach, that amount will be paid, then that amount also a party cannot claim as a matter of right. It is the discretion of the court to award the reasonable damages subject to a maximum of that outer limit which is mentioned there. That is a separate concept. But I am on the example which I had given, there was no specific amount mentioned in the event of breach. Let's assume there is a contract of sale of a property where a person says that if you commit breach, you will pay double the amount or 10 times the amount. Or let's assume there's a lease agreement, and the agreement says that the rent is 10,000 and the lease is for 1 year. But if the tenant continues to occupy more than 1 year, then instead of 10,000, he will pay 1 lakh 10 times. So question rises whether that 10 lakh can be claimed. Answer is that the court has the discretion to award reasonable damages which the landlord would have suffered subject to a maximum of that 1 lakh. So in any case, it can never go beyond what is stipulated. But the person has to show how much loss he has suffered. So therefore, in that landlord-tenant case, the court will find out what was the market value of the property after 1 year. If the market value of the property was, let's assume, market rent was, instead of 10,000, it was 15,000 per month. So court may say, all right, we'll only award you 15,000. So therefore, we were not, that position itself is clear by 74. Today, we are not going into that situation at all. We are saying even that general damages which are there, for computing that general damages, one general trend of the parties is to claim the amount which he would have ordinarily suffered. So if you apply the test of ordinarily suffered, let's assume a person, as we had taken that hotel case, where a person would have, there was a claim of 20 crore on a basic principle that if the contract would have continued, the person would have earned 20 crore. So one logical approach can be that, all right, it is very, very fair. If in 19 years, 20 years, 20 crore would have been earned, so please give 20 crore. But that claim, but this preposition does not take care of number one, mitigation. What about mitigation? There is a duty of mitigation. we'll take a very simple example. So a person orders a truck of apples from Kashmir, and when the truck comes, the person refuses to take delivery. So that person can't claim the whole value of the apples. He has to go to the market and sell that and get whatever he wants to get. And then he can claim whatever is the difference between the contract price and the price at which he sold the material. So this is the concept, basic concept of mitigation. But in the example which we have taken, apart from mitigation, then the question arises, what is the net profit before tax? So therefore, if the net profit before tax in every transaction by that person was only 8%, so therefore it is only 8% which can be claimed, not beyond that. But this principle is very rarely been invoked. Therefore, my only point of taking up this issue today was that we should apply these principles. We should understand these principles well and invoke in a right perspective to claim the actual damages which can be awarded by the arbitrator. Thank you, Vikas.
Yes, sir. So the next question is, normally Saket says that the Supreme Court recently has said that with the consent of both the parties, the matter has been remanded back to the arbitrator. Is there any provision for the same? And can it be said to be a
I think it is today's clip I have seen. I have not yet read the judgment. It is today come in live law or bar and bench.
So I didn't also examine that because today I was reading more on hijab, and especially the Karnataka full bench was live on the YouTube. So I was watching
just saw that clip on the mobile. I have not yet gone through the judgment, but this what you are saying, it has come on the that clip was circulating. So we'll have to examine it and then we'll discuss that.
Yeah. And then he says, well, all the states which follow the
but at the same time, because we'll discuss the judgment when we go through it. But at the same time, you see, there are many otherwise, but for this proposition, to my mind, it is again a positive development. There are many cases where earlier view was that you can't remand back, so the courts were handicapped. So therefore, now as the clip says that with the consent you can do it, to my mind, it is a positive development. Otherwise, you see, ultimate aim of whether arbitration or the judicial proceeding is to do complete justice between the parties.
That's the cardinal principle. Justice must not only be done, but seem to be done.
So if we set aside an award and then say everything is closed, now where is the justice gone?
So that's what I'm saying. The cardinal principle continues.
Therefore, this, although we'll discuss in detail when we see this judgment, but on the face of it, this is to my mind a very positive and welcome step in the administration of justice. Ultimate aim is to do justice. And if there is a conflict in law and justice, the law should bend and justice should prevail. Not that justice should bend and law should prevail.
That's true.
So therefore, to my mind, for the time being, this is sufficient to say it is a very positive, welcome step.
Yes.
In the development of law relating to arbitration. Right. No other law in our country has developed so much as the arbitration law. It has totally overhauled in the last 1 decade. And
one of the version is that the arbitration is so enriching that the best of the brains are coming forth, therefore the best of the development of the law is coming forth.
No, that is, I agree with you. This is a good reason. But another reason is that the investors will not come to India unless there is a assurance.
No, I'm saying that reading the sections threadbare, it is only coming because the best of the brains are applying.
Very right. So therefore, all over the world, this law is developing, and the domestic economy and the world economy will rise only with a very strong arbitration system. You see, if the investor finds that here, if he is entangled in litigation and he will not get justice expeditiously, then the investor will not easily come here. Therefore, it is in our national interest that we have a very strong arbitration system where we give immediate justice.
That's true.
And you see how nicely Singapore International Arbitration Center has become a hub in a very short time. Most of the cases, the dispute is between two parties in two different countries who choose the Singapore as a neutral arbitration center for doing the arbitration. So therefore, to my mind, it is a most important thing to develop it. It is the interest of the country also and economy also.
That's true. They say economy thrives on the how much industry is chipped in. What are the facilities and what are.
Yes.
Thank you, everyone. Not only those who are watching us live on the Facebook, YouTube, and on this webinar. Thank you, sir, for sharing your knowledge. And those who have been connected with us and those who want to have the further updates, do connect with us on Friday on Fundamentals of Interpretation of Contracts by Mr. N.L. Raja, a senior advocate from Madras Bar Association. Thank you, sir, once again for sharing your knowledge. Thank you.